I'd like to introduce our guest speaker today, Professor Nadine Strossen. She is one of the most high-profile advocates for civil liberties in the United States. She's a professor of law at the New York Law School and has written important scholarship on American constitutional rights and civil liberties. She's also a member of the Council for Foreign Relations, and she served as the first female president of the American Civil Liberties Union, the American Civil Liberties Union, from 1991 to 2008. She earned her JD magna cum laude from Harvard Law School in 1975, where she also worked as the editor of the Harvard Law Journal. It's a very prestigious thing to do if you're in law school at Harvard. And her most recent books include Hate, Why We Should Resist It with Free Speech, Not Censorship. It's Oxford University Press, 2018. And Free Speech, What Everyone Needs to Know, Oxford University Press, 2023. So please join me in offering a very warm UBCO welcome to Nadine Strossen.
Thank you. Thank you.
And my first question is about just your general approach to free speech, why you think it matters so much, what the philosophical underpinnings are in your understanding of why it's so important today.
Well, thank you so much, Jeff, Matt, everybody here for spending your precious time to engage in this topic that I do believe is crucially important. In fact, to slightly amend that excellent biography, Jeff, to underscore how important free speech is, I love teaching, and I had very good teaching evaluations, so my students seem to love me too, if I do say so. But I voluntarily took emeritus status from full-time teaching at the end of 2019 so that I could crusade full-time in support of freedom of speech, including spending most of my time educating about free speech, because I've found that the more people know about the principles and the importance of free speech, the history of censorship that gave rise to it, the adverse consequences of not having free speech, the more supportive they become. So since the end of 2019, I've been traveling around the world talking about it. So I obviously really believe it's important. As Jeff indicated, I have been a full-time crusader for the full panoply of civil liberties and human rights, the ACLU, in which I'm still very involved as a member of its National Advisory Council, defends all fundamental freedoms for all people. We believe that no matter who you are, no matter what you believe, you have certain fundamental rights by virtue of being human, and that it's government's responsibility to protect those rights, far be it from government to restrict those rights. I still continue to passionately adhere to that entire human rights, civil liberties agenda. So it's not that I think that free speech is in some abstract sense more important than equality or dignity or due process or fairness or privacy, all of the other fundamental liberties. But what I do believe, based on my own now many decades long experience, as well as my reading about what's going on in other parts of the world, including Canada, and my reading about human history, I believe that freedom of speech is the absolutely essential prerequisite for protecting and advancing every other right. Indeed, it's the essential prerequisite for protecting and advancing any cause at all. So if your favored cause is environmental or immigration or animals' rights, just you name it, gun rights, you absolutely depend on the freedom to advocate, persuade, petition, to associate with others, to assemble in public to advance that right. So I'm now talking about an instrumental value of free speech. It's essential for advancing whatever causes we subscribe to. It's also an essential instrument for the democratic form of government in which all of us are so privileged to participate. To quote the opening words of my Constitution, and I know there's a similar sentiment in your country, we the people wield sovereign power. How can we do that effectively unless we have freedom of speech in the fullest sense, which means not only the right to debate and discuss with each other, but also with respect to those who seek our votes to be our elected representatives in Parliament or in Congress, respectively, and to hold them accountable to whatever our priorities and preferences are. Freedom of speech involves not only the right of people to convey information and ideas, but also the right to receive information and ideas. So we have a right, which is very essential in a democracy, a democratic form of government, a right to receive information about government policies and government decisions. Moving beyond the really important instrumental functions of free speech, Jeff, there's also an more intrinsic value, and that is in terms of self-exploration, self-knowledge, developing an awareness and understanding and shaping of your own identity. It's essential to have freedom of speech to do that. One of my favorite phrases from a United States Supreme Court decision was a passage by Anthony Kennedy, who said, and I'm so sorry, I may not have the words exact, I'll do my best. He said, freedom of thought is the beginning of all freedom, and freedom of speech is the beginning of freedom of thought. And that really has always stuck with me, because the first time I read it, I thought, isn't that backwards? Don't you need to have freedom of thought before you can have freedom of speech? But then I realized, and as all of us who do writing as part of our academic enterprise understand, that the process of writing, right, or of expressing ourselves orally as well as in writing, helps to crystallize and to formulate your thoughts. And there's that famous statement from the philosopher Rene Descartes, I think, therefore I am. So putting Justice Kennedy's idea into that, I speak, therefore I think, therefore I am. And when we think of so many essential, important constituents of our self-identity today, expression about our gender identity or our sexual orientation. I'm old enough when I remember that these were far more embattled rights than they are still facing many challenges today. But being able to even declare yourself as a gay person or a queer person was such a huge step. And the very first step, not only toward advancing the cause of equality, but also toward defining yourself, expressing yourself to yourself and to your larger community. So I'm sort of channeling one of the most, I think, enduring, eloquent descriptions of the importance of free speech that came from an opinion by Justice Louis Brandeis, a great Supreme Court justice in the early part of the 20th century. It was an opinion that was essentially a dissent, but has subsequently, like 50 years later, was unanimously endorsed by the Supreme Court as an official decision. And he said, freedom of speech and liberty in general is essential both as a means and as an end. And that's really what I've been explicating, both the instrumental importance of free speech and the intrinsic importance of free speech.
That's a fantastic answer. Sort of like the right of rights to you, then, in a way. It's a phrase Jeremy Waldron uses in relationship to voting, but for you, that's freedom of speech.
And he and I have debated each other on precisely because I put more importance on speech. But actually, I think that voting is itself an exercise of freedom of expression. And again, I don't see how the vote could be meaningful without the most robust freedom of expression. I actually, I should say one of the really important purposes of freedom of speech I haven't even alluded to, but here in an academic setting, I think I should say it, which is as a means to pursue truth. Truth in every sense of that word, whether it be scientific truth or social scientific truth or truth in the sense of religious or philosophical values.
And not just in university, in the wider society. Okay, I want to talk more about universities a bit later, but before we get there, I thought I'd ask about how you came to care so much about this, because in what you said, there's a mixture of philosophy in there and also just passion, obviously, giving up your status in the classroom to go and pursue this, right? So how did you come to care so much about free speech? How did it become such a thing you wanted to crusade for?
I have believed so strongly in freedom of speech as far back as I can remember, Jeff. I remember being a little kid and having some conflicts with both my parents and my teachers when they suppressed my free speech at a time when I didn't have the vocabulary, but it was just an instinctive notion that I should be able to express myself. I should be able to question authority, including parental authority and my teachers. And I was thrilled when I learned that there is actually not only legal protection for what seemed to me should be an innate right, but also that there are organizations in your country as well as mine and all over the world that are dedicated to protecting that freedom, including for young kids. And you won't be surprised with that background. One of my pet causes has always been not only freedom of speech, but all fundamental rights for young people and students. And I'm very proud of the work that the path-breaking work the ACLU has done in both areas. So when I think the first time that I did something serious, more serious than just questioning the teacher or questioning my parents, I was about 13 years old, and this was during the early phases of the Vietnam War, which was then very, very popular in the United States. It was extremely unpopular to criticize the war in any sense. And I had a teacher who put together a series of slides that simply depicted some scenes from the war. Now, obviously, they were selected, and they were scenes that showed civilian casualties and bombings, and there was no verbal commentary. There were some folk songs. There's no doubt that the tenor of it was to question American policy, if not overtly to criticize it. And when word got out about this slideshow, there was an uproar. This was in suburban Minneapolis. And the local newspaper editorialized that the teacher should be fired, and there was a substantial petition drive to fire the teacher. So I organized a counter petition drive among my co-students, and I wrote my first letter to the editor objecting to the editorial of the newspaper, and then they responded to me, and I responded to them. We were off to the races.
And that got you going, eh? Okay. Well, we're in Canada, and Canadians, in my experience, and I speak for myself, having been a Canadian studying in the US, are not always as We like to talk about U.S. politics. We like to say we know a lot about it, but we're not always as knowledgeable as we pretend. And so I was wondering if you could say a little bit more about the First Amendment and the role it plays as an instrument, because it's one of the primary legal instruments by which you have advocated for freedom of speech. You can tell us more about how it works and what role it plays in American political life, broadly speaking.
So the First Amendment, which was added to our Constitution, was ratified in 1787. And there was a lot of ferment during the ratification process by factions who believed that this Constitution, which gave broad new powers to the central federal government. So one thing our two countries have in common is a federalist structure, right? And we had a prior Constitution in our country. It was called the Articles of Confederation, which had an extremely weak federal national government, and because those who fought the revolution, by the way, the rebellious people apparently stayed on my side of the border, and those who were more supportive of the Crown stayed with Canada. So I think we have somewhat different national temperaments historically.
For the record, they moved to Ontario, for the record.
I've had many debates with my Canadian friends, and I think on the whole, there is more of an individualist emphasis in the United States, and in Canada, more of a community, very proudly, right? And I've done a lot of debates with Canadians about our differences on free speech, and it's very clear that in the for every generalization, there are obviously exceptions, but on the whole, the culture in my country is to be distrustful of government, whereas in Canada, I keep encountering the sentiment, but the government is going to protect us, and if it's the government that's enforcing the law, of course they're going to do it to protect people and their safety and their dignity. So there are somewhat different emphases, but there was this very, very strong distrust of government that animated the American Revolution, and a general belief that the more localized the government is, the more directly accountable it is to the people, the less dangerous it is. So under the Articles of Confederation, the power was essentially given at the state, in your case it would be at the provincial level, with almost no power at all in the central government. And that turned out to be completely unworkable. The different states were essentially like independent sovereignties that were imposing taxes on each other and restricting immigration, and it just wasn't functioning. So there was a constitutional convention which gave a lot more power to the new federal government with very few explicit guarantees of individual rights in the original Constitution. It wasn't because the framers thought that there should not be individual rights, but they were creating a national government that, even though it had far more power than under the Articles of Confederation, still was a government of strictly limited powers. So the Constitution and the article that created Congress said Congress shall have the powers that are enumerated herein. And the enumerated powers did not include the power to make laws that abridge the freedom of speech. So the framers said, we don't need to expressly say, thou shalt not abridge freedom of speech, because Congress doesn't have that power in the first place. In the ratification debates, it was determined that, we should err in favor of saying it again. And so the Bill of Rights was added in 1791 that expressly said, starting in the First Amendment, Congress shall make no law abridging the freedom of speech. And, even though that existed as a matter of law since 1791, it had no actual real impact, or virtually no actual real impact, until the second half of the 20th century. For the vast majority of the history of the First Amendment, they were just words on a piece of paper. James Madison, the primary architect of both the Constitution and the Bill of Rights, had said, it's going to be a mere parchment barrier between the people and government abuse. It's not self-executing. And so we had horrendous censorship, including especially of every advocate of any law reform, including advocates of human rights. So the abolitionist movement was severely subject to censorship, even to the point that Congress itself banned petitions against slavery. So, completely thwarting freedom of speech, where it should be most important in the seat of the power of the legislative branch of government. Women's suffragists were suppressed. During World War I, my organization, the ACLU, was founded precisely because of such rampant violations of free speech for anybody who criticized the war effort. Conscientious objectors, pacifists, any critics of U.S. policy. 15,000 people were imprisoned merely for peacefully criticizing the war or the draft. So the First Amendment might as well not have existed. And the ACLU, and I should say this is true for other constitutional rights as well, the Equal Protection Clause, which was added after the Civil War, and you probably all know we had Jim Crow and racial segregation by law, again, until the second half of the 20th century. No coincidence. The very same Supreme Court, famously known as the Warren Court, named after Chief Justice Earl Warren, that began to strongly enforce freedom of speech in the mid-20th century, also began to strongly enforce the Equal Protection Clause. And there was no coincidence, because, as had been true throughout history, the power to censor was used to stifle advocates for civil rights. And in order to unleash that movement, to allow the civil rights demonstrators to protest injustice, to allow the national media to cover them and gain the attention that ultimately led to the enactment of the historic 1964 Civil Rights Act, it was necessary to really put teeth into the First Amendment. And Brandeis's dissent from the early part of the 20th century was adopted in 1969 unanimously. So, and then you asked me to summarize the basic. If I had to give you one principle in this whole long collection of decisions that the Supreme Court has issued, starting pretty much in the early 20th century, so hundreds and hundreds of decisions with many principles and subsidiary principles, if I had to choose one to give you the essence of First Amendment law, I would tell you, and I will tell you, about what the Supreme Court has called the bedrock principle that underlies everything else. And it is usually called content neutrality or viewpoint neutrality. And that means that government must remain neutral with respect to the content, the idea, the message, the viewpoint of the speech. No matter how unpopular, no matter how hated, no matter how hateful the message might be, it is not government's role to restrict it for that basis. It is for we, the people, us as individuals, to decide that we loathe that speech, that we're going to ignore it, that we're going to refute it, that we're going to persuade the speaker to reject that idea. So in other words, and this idea, again, traces back to Brandeis's dissent, now unanimously endorsed, rather than government suppression of ideas or content that we hate or fear, we have to have more speech, which is often called counter speech, in order to rebut it. So that is the core principle that I would start with. But if I can give you just one more principle, I think it's really enough to get at the essence of the whole legal structure. And that is often, again, tracing back to Brandeis, it's often called the emergency principle. if you get beyond the content of the speech, its message or its idea, and you consider it in its overall context, if in the particular factual scenario, the speech poses an emergency, not because you dislike the idea, but because it directly, imminently causes certain specific, serious harm beyond being insulted or offended by the idea. And the Supreme Court has recognized several subcategories of expression that satisfy this context-based emergency concept. And I know you've heard many of these ideas before. So one is intentional incitement of imminent lawless or violent conduct that's likely to happen imminently. Another one is a so-called true threat. The word true is thrown in there to distinguish it from the loose way we use threat in everyday speech. But to be a legally punishable true threat consistent with the emergency principle, the speaker has to target a specific individual or small group of individuals and intend to instill a reasonable fear on the audience's part that they're going to be subject to an attack. Now, the speaker doesn't have to intend to actually carry out the attack, because if you're the target and you have an objective fear that you're going to be subject to attack, that already causes you harm, right? It stifles your own freedom of speech, and it probably interferes with your freedom of movement as well. Another example of speech that satisfies the emergency principle is targeted harassment or bullying that interferes, again, with the privacy or freedom of movement of the targeted individual. So to me, these principles really completely accord with common sense. On the one hand, they allow government to outlaw the most dangerous speech that poses an emergency, has a tight and direct causal connection to harm. On the other hand, they outlaw the censorship that is the most dangerous. Why? When the censorship, when government is picking and choosing which ideas and which viewpoints are going to be allowed or disallowed. That is the most dangerous form of censorship to both individual liberty and to democracy.
This is a great summary. It's far better than I could ever do. I'm just wondering, in that idea, that bedrock content neutrality, viewpoint neutrality, that concept is not so central in our doctrine, although the idea is there and expressed in other ways. But do you see that idea of viewpoint neutrality as being bedrock as completely incompatible with the idea of hate speech?
Hate speech doesn't have a legal definition either in your country or mine. Other languages use. So let me just say, Jeff, that speech that conveys a hateful message may and should be punished when the emergency standard is satisfied. So many of you have if not all of you, have heard about the controversial congressional testimony of 3 university presidents in the United States on December 5th. And they were pilloried because they were asked repeatedly, does advocacy of genocide violate your campus policies? This gives me an opportunity to make another really important point, which is the First Amendment only applies to government, right? It says Congress shall make no law abridging the freedom of speech. And the Supreme Court has interpreted the word Congress as meaning all government officials at every level and branch of government. So a state university official, a state university would be bound by the First Amendment, but private universities are not. Nonetheless, virtually every single private university in the United States has voluntarily chosen to adhere to the same First Amendment standards it would be required to adhere to if it were a public university. They say because it's consistent with our view of academic freedom, it's consistent with our view of effective pedagogy, it's consistent with our responsibility to be educating future citizens and leaders of our democracy. So I'll, for shorthand, refer to the First Amendment, but please bear in mind that these private campuses were not directly bound by the First Amendment itself. But the answer that they gave, and it was mocked, and it was derided, and it was attacked, the answer was technically, legally correct, as you now all know from what I've said, that when they were asked, is advocacy of genocide inconsistent with your campus policies, again, campus policies having incorporated First Amendment standards, and the answer was, it depends on the context. That is a correct answer. So students who are demonstrating in an open area of a university campus, chanting slogans that may or may not be intended to be or received as genocidal, even if they expressly said, we advocate genocide, that would be constitutionally protected. And let me expand on that a moment. I said that the Brandeis opinion that had been dissent, essentially, was unanimously adopted by the Supreme Court in the second half of the 20th century. I was referring to a landmark case called Brandenburg versus Ohio, decided in 1969. I'm very proud that it was an ACLU case. And that involved a Ku Klux Klan leader who was advocating, if not genocide, he used the term revengeance against Jews and against Black people. And the Supreme Court literally said, advocacy of violent or lawless conduct is constitutionally protected. No exceptions for genocidal violence or lawless conduct. Mere advocacy is protected. You cross the line, the Supreme Court said, and here you'll recognize a concept I referred to earlier, you cross the line only when it becomes intentional incitement of imminent lawless or violent conduct that is likely to actually happen imminently. A very tough standard to meet, one that's not impossible to meet. And in fact, there's a lot of debate, and so far we have three, to the best of my knowledge, three different judicial rulings in the United States on this question, and the courts have split 2-1 on whether Donald Trump's speech in the Capitol on January 6th could be punishable under the Brandenburg standard. And it's a very fact-specific standard, as all of these context-based emergency concepts are. And so you have to look at not only the exact words that he used, but the overall context, including leading up to the rally and et cetera. I guess what I'm saying is that some hate speech can and should be protected, but prevented. But I would not loosen up the standard to move in the direction that Canada and most of the other countries in the world have gone. And let me tell you what the alternative is. Different countries formulate their laws differently, but essentially it comes back to what we used to have in the United States as our standard before 1969. It's usually referred to as the bad tendency test. In Canada, I know you use the word reasonable. To me, it's pretty much all the same, that you're giving discretion to the decision maker to determine that even if the speech doesn't imminently directly lead to these articulable, demonstrable harms, if there is a tendency on the part of the speech to indirectly potentially at some point in the future cause harm, that's enough to justify punishing it. And I don't at all mean to deny that speech that doesn't satisfy the emergency standard, of course, can contribute to great harm, and does, in particular circumstances, contribute to great harm. The reason why in the United States our justices continue to insist on the emergency standard and not to give government more latitude under the reasonableness standard or the bad tendency standard is the experience that, dangerous as non-emergency speech is, it is even more dangerous to give the government that added latitude, because that will predictably be used to stifle the dissidents, the minority groups, the marginalized, those who are advocating for change.
Well, we're getting right into the Canadian system. Why don't we talk a little bit more about that? Section 319 of the Criminal Code does prohibit hate speech, and one part of it prohibits hate speech in a way that's similar to these conditions, in that it prohibits hate speech linked to incitement. But other parts very clearly do just strictly seem to prohibit willful promotion of hate speech.
And it's not only incitement to violence, as I recall, Jeff, but it's incitement to hostility or hatred, right?
Disturbance of the peace, which is broader than again, that's already a looser standard, which is why you're saying reasonableness, because that ends up being part of how judges establish what on fact-based situations, what counts as a disturbance, right? Or a tendency to disturb, right? But there's also parts of the criminal code, that section, that just seem clearly not related to anything like incitement, but just are about prohibiting a certain category of speech. And we have one very specific provision of the criminal code that just bans the outright denial or diminishment of the Holocaust, which seems to be completely unlinked to any specific fact-based threat, right? It's just content. It's a very content-focused rule. Now, one thing I'm interested in is first, like, just what your take on that is. It sounds like from your account, these laws would just be unconstitutional under the American standard, right? Now, what's interesting to me is our courts have upheld these laws.
Well, over some dissents, in fairness.
So a very famous dissent you probably are a big fan of is Justice McLaughlin's dissent in Keegstra. I'm also a fan of her dissent. And you probably noticed something in the majority opinion in Keegstra, which is that the idea of what justifies hate speech is actually much more predicated on how you're allowed to override or infringe freedom of expression or limit it. Under Section 1 of our charter allows for the establishment of reasonable limits on rights. And the way the court deploys that often, at least after 1986 in the Oakes test, is to say, okay, well, Parliament can set limits on rights in the sense of infringing them for justifiable reasons, right? Now, we met on a panel where our colleague, Jamal Green, has written a book arguing that way of approaching rights, of having courts look at limits as being, limits on rights as allowing them to establish balance the interests at play in different rights scenarios. He's arguing that that's the way to go. And we were met on this panel where we both were, pushing back on that a little bit. Do you think that's part of the big problem we have in Canada, is that courts have allowed the idea of limits on rights in the sense of letting them just balance interests overriding rights? Is that part of the key here?
And Jeff, I don't want to come across as some jingoistic, American citizen of the United States who's, preaching to Canadians that we're better than you and our system is better than you. Because as you and I illustrate, there are people, and I've spoken in countries all over the world, there are people in every country who have a more libertarian orientation, an orientation more in favor of individual rights. And believe me, there are a lot of people in the United States States who think we should move more in the direction of Canada. In fact, there are recent surveys that show that if not a majority, a very heavy plurality of people in the United States wish that we would have more restrictions on hate speech, on disinformation, on extremist speech. There's a big, if I can say something else about that.
Yeah.
You know, one of the things that prompted me to write my most recent book is this disparity between the United States Supreme Court and judges in general, but I'll use the Supreme Court as an example, and the general population. So we have 9 justices, as you may know if you follow what's going on there at all. They are deeply polarized, very ideologically divided. They split at least 5-4 in constitutional cases, and often they're more fractured than that. But on these free speech principles that I've been talking about since 1969, we've had a huge, very diverse array of justices since then. To the best of my knowledge, every single one of them has agreed with these fundamental principles that I'm talking about. Every single one of them has opposed expanding government power to allow suppression of more hate speech or pornography or disinformation or extremist speech. So you have the justices on the one hand, and then on the other hand, all across the ideological spectrum, we have many members of the public who want to censor that speech that the Supreme Court is protecting. So what accounts for the disparity? Obviously, one major difference is that the justices know the law, and they're also familiar with the history and the experience that gave rise to it. So my thought was that, you know, if more people would know about these legal principles, there would be more support. But the Canadian situation was clear. I remember before the Charter of Rights and Freedoms was adopted, and when I first saw the proposed text, I thought, well, that's not a Bill of Rights at all, because it is, and forgive me, I haven't looked at the details in such a long time. I remember not only the exceptions clause, but there was another clause that allowed it to be, the whole thing to be suspended, right?
Well, Section 1 of the Charter allows the legislatures to establish limits that can be justifiable in a free and democratic society. And then Section 33 allows laws that can be enacted notwithstanding certain sections.
Right.
So it's famously called the notwithstanding
clause.
The
notwithstanding clause, exactly. And so what distinguishes, to me, a real, I say this with the greatest respect, please, I don't mean to sound patronizing. What distinguishes a constitution from another kind of law is we usually use the term entrenched. That means that it's not impossible to make an exception or to change it, but it is deliberately much harder to do so. So we can amend our Constitution, but it requires supermajority votes by both houses of Congress and by state legislatures. And to me, and there are no exceptions that are stated with respect to any right at all in our Bill of Rights, with one exception, which has to do with our extremely punitive criminal laws, but no exception. You know, Congress shall make no law abridging the freedom of speech and so forth. So when I read the proposed language of your charter, you know, it seemed like it would give more tools, perhaps, for protecting individual rights, but not as entrenched and as durable a rule if the right can be subject to ordinary balancing that we use in the process of evaluating, you know, legislation that deals with every other subject under the sun. In the United States, when arguments are made that we should balance freedom of speech against concerns for national security, public health, children's welfare, very, very important interests, the Supreme Court repeatedly says the balancing was done by the framers. And the balance they struck was that freedom of speech should be protected. Again, not absolutely protected, but the emergency standard really puts a presumption against the restriction. To me, the language in your charter has been faithfully applied by the judges as it's written, which does not put such a heavy thumb on the scales in favor of individual rights. Again, to me, there's more of a trust here that, government's doing it, they've got a good reason for doing it, and, we'll benefit from government decisions.
That's very interesting. I can't help myself, but I can't help myself but ask a little bit more about your views on the notwithstanding clause, because the notwithstanding clause is put in partly because when the charter is being negotiated, the provinces know that all of our appellate courts and Supreme Court are appointed by the federal government. Mm-hmm. And so they're partly worried about the charter being used in ways that erode their jurisdiction, mm-hmm. and maybe even are used to put forward views on rights that are unpopular within their own province, mm-hmm. but maybe nationally mm-hmm. popular. And I'm wondering about that. Is there not a freedom protecting aspect of the notwithstanding clause as an instrument of federalism in your view?
That's a very good point, because federalism, to the best of my knowledge, is not that common a form of government. It's one thing that binds the United States, Canada, Switzerland's the other major example that I can think of. And that was part of the reason why we did not have an express Bill of Rights at all in our original Constitution, was not only that Congress was given limited enumerated powers, but also we had this system of divided powers at the federal level, and then separation of powers at the national level among the three branches of the national government, and divided powers between the federal and the state. And by limiting and dispersing and having checks and balances, that famous phrase, that was seen as an essential instrument for protecting individual liberty. So I think that's a very fair point. Thank you. I always I'm illustrating how I'm learning and changing my mind, and I hope everybody has learns at least one thing, and at least considered changing your mind about at least one thing as a result of this program.
Well, if I've convinced you the notwithstanding clause might not be so bad, then I consider this a pretty good interview. But I want to go back to freedom of speech. And federalism is definitely interesting and related, but I want to just ask a few more questions about hate speech in our country, which is, you already said it today, that the best way to fight hate, in your view, is with freedom of speech. And I mean, we kind of have one of the most famous cases that the ACLU litigated was the Skokie case, right? Where this, we talk about it a bit, but there was a neo-Nazi march through this Jewish town. Is it in Illinois?
Yeah. So Skokie, Illinois, is essentially a suburb of Chicago, and when the case took place in the late 1970s, not only was there a large Jewish population, but many of them were actually Holocaust survivors. And when this neo-Nazi group wanted to demonstrate in front of town hall, and my organization, the ACLU, which from the beginning has been fully committed to equal rights, civil rights. Nazis could not be more antithetical to the ACLU's principles about equality. So we could not have disagreed more with the content of their speech, but we were supporting the content neutrality principle and came to their defense, and it was an easy case in the courts of law. The case went all the way up to the United States Supreme Court, and it was such a slam dunk winner in terms of the viewpoint neutrality principle, because there was no evidence of any violence or anything that would satisfy the emergency standard. It was simply their obnoxious views as a justification for that was put forward as a justification for suppression. But even though it was a slam dunk winner, I was starting to say it was such a clear legal principle that the Supreme Court did something very rare. It decided in favor of their free speech rights without even receiving written briefs or oral arguments. Just, we know enough now, just based on the facts, this violates the viewpoint neutrality principle with no dissent. But it was a very much of a loser in the court of public opinion, including even among ACLU members. People who believe so strongly in free speech that they paid their $20 dues, and that's an advertisement, it's still very cheap membership, to become card-carrying members. And people said, you know, I really do believe in freedom of speech, but this goes too far. This is the one exception I think should be made for the most egregious, dangerous speech. And as one of my friends observed at the time, everyone has his, her, or their Skokie, right? The one exception they want to make for the message that they consider to be the most dangerous. And I can actually look back on my history as a free speech advocate, and for different periods in history, for different portions of the ideological spectrum, I can tell you what was, you know, for some feminists in the 80s and you know, coming back again today, it's pornography. That was a big thing here in Canada. That is demeaning or subordinating to women. For many liberals in the United States, starting in the 90s, when we started to have school shootings, it was violent video games because the kids who were school shooters were looking at it. In the post-COVID, after 9/11, any expression that is extremist or pro-terrorist, in the COVID era, disinformation about health. Most recently, especially after 2016 and January 6th, any disinformation about elections. And then I could go, those have been the exceptions that the left end of the political spectrum has wanted to make in the United States. For the right end of the political spectrum, it's speech that endangers traditional family values or is unpatriotic or is inconsistent with our religious beliefs and so forth. And the problem, as you see, is if you add up all of that just one exceptions, there's nothing left to freedom of speech.
So I was just thinking, like in the wake of the October 7th attacks by Hamas on Israel, I mean, even before Israel responded, there were demonstrations in Montreal and Toronto and other major cities where people seemed to be, for want of a better word, celebrating what was going on or excited about it. And there were several hate speech uses of our Section 319 to charge some of those individuals. And you would argue, how would you argue against that? Are you arguing that this is not an effective way to deal with this, or?
Well, first of all, less than a week after the terrorist attacks, I was reached out to by Barry Weiss. I don't know if that name means anything, but she's the publisher of something called The Free Press. She's she's passionately in favor of freedom of speech and individual liberty, and she's passionately a crusader against anti-Semitism. And she reached out to me. She said, Nadine, we need a piece about why even anti-Semites, even people who advocate genocide, should have free speech. And I know that that's what you believe. And I thought that was so interesting because there's not anybody I can think of who has more strongly been complaining about what many people see, she certainly sees, as rising anti-Semitism, especially coming from the left, in addition to the traditional right-oriented white supremacy bases of anti-Semitism. That, to her, that was not at all inconsistent with freedom of speech for anti-Semites or advocates of genocide. And rather than quoting myself, let me go back to that Skokie case because the national executive director of the ACLU at the time was a wonderful man. He's still alive, a good friend of mine named Aryeh Neier, who was himself a Holocaust survivor. Aryeh was born right before the end of the Nazi era in Berlin. His extended family was completely slaughtered by the Nazis after fleeing through several other countries and going through other horrible experiences. Aryeh's immediate family came to the United States, and he became the executive director of the ACLU. He then went on to become, just a giant in international human rights. But he was the one who spearheaded the ACLU's defense of freedom for the freedom of speech for the Nazis. And believe me, he certainly received a lot of hate speech, if not, worse, true threats as a result of it. Immediately after that case was over, he wrote a book, which is still one of the great defenses of free speech. I rank it up there with John Stuart Mill on liberty. I reread it every few years. It's called Defending My Enemy. The subtitle is something about the risks of freedom. And by the way, if anybody is interested, it's out of print, but REA gave me permission. I've got a PDF. I will send it to anybody who's interested. And it is such an eloquent statement about how if anybody depends on freedom of speech, it is Jews and any other minority group, because by definition, those groups lack access to the levers of power. And I can't do justice to his eloquence, but he basically says, how are we Jews going to be able to cry out to each other for succor and to the world for support if we don't have freedom of speech? And I think if I look at other countries, including Germany, that do suppress hate speech, including anti-Semitic speech, we certainly have problems in this country. I spend in my country. You have a few problems in yours too, I dare say, but I don't think that the situation for Jews or other minorities is any better in countries that have strict anti-hate speech laws. Let's take Germany, for example. A lot of people say, but if only the Weimar Republic in Germany, during which Hitler rose to power, if only they had had hate speech laws, then Hitler wouldn't have risen to power and maybe the Holocaust wouldn't have happened. Historians call this the Weimar fallacy. Why? Because there were very strict anti-hate speech laws in the Weimar Republic. Criminal laws, civil laws. There was a very vibrant Jewish organization similar to the Anti-Defamation League with chapters all around Germany. And they would bring complaints. They financed complaints. And there were dozens and dozens and dozens of successful criminal prosecutions and civil lawsuits against leading Nazis. The leading virulently anti-Semitic publication, Der Stürmer, published by Julius Streicher, was banned multiple times, prison sentences imposed. Hitler himself was banned from public speaking for almost 2 years. And we saw what happened. Historians, the consensus of historians, and certainly of the Nazis themselves, was that these trials were propaganda platforms for them. They gained attention they otherwise never would have, and sympathy that they otherwise never would have. In Germany to this day, they have the strictest anti-hate speech laws in the world, according to international human rights experts, and yet the problems of not only hateful speech, but hateful violence and discriminatory violence are profound. I don't know how much you follow it, but there have been brutal attacks against Jews, against refugees, against Romas, against immigrants, to the extent that while she was still chancellor, Angela Merkel, for the first time in German history, appointed a cabinet-level minister for anti-Semitism. And that person, as well as the head of the umbrella organization of Jewish groups in the country, issued a pronouncement in about 2018 that it is not safe for Jews in Germany to wear a yarmulke in public, the skull cap that certain Orthodox religious Jewish men believe it's their religious obligation to wear. Why? Because if they are publicly identified as a Jew, they will be subject to attack, and there have been many such documented attacks. Now, in fairness, let me tell you the limits of the point that I'm making. I made all of these points in a debate I had a few years ago in Brussels with a woman named Vera Jourova, who is the EU commissioner. I think of her as the EU censorship czar. That's not exactly her title, but every time you read about the EU coming out with another edict against disinformation or hate speech, she's always the one behind it. And I gave this information about Germany, and it's replicated in France and Britain, and Jews in Europe really feel under attack, as do many, many, many other minority groups, including Muslims and other religious minorities. And she cheerfully agreed with me that the problems of hate speech and hateful and discriminatory crimes and violence were rampant in all of these countries, notwithstanding the strictly enforced anti-hate speech laws. And we reached diametrically opposite conclusions. And I don't think that either one can be scientifically, empirically proven. If anybody can help me on this, be my guest. My conclusion was this evidence shows that these laws don't work and they should be repealed or not enforced. Her conclusion was, yeah, these laws don't work. That means we need more of them and stricter laws. And I think, in some ways I have to acknowledge, I think that this goes back to a point I made earlier about the somewhat different orientations historically of our two countries. Do you start with a presumption in favor of liberty, and if the government can't prove that the restriction is effective, then free speech prevails? Or do you start with the opposite presumption that government is to be trusted to protect against harms, including dignitary harms and harms to safety? And unless you can prove that an added law is not going to be effective, then the added law will go into effect. And I think that's very much what is happening in Europe.
That's very interesting. On the note, I want to conclude with one more question on our context, and it's encouraged because on our walk over here, you mentioned that you had read the trial court decision in Ontario about Justin Trudeau's government's invocation of the Emergencies Act. And I was wondering if you might say a few words about that and your impression of it.
It was such a fantastic decision. I would highly recommend it to everybody here. I mean, not necessarily to read all 190 pages of it, and I must admit that I skimmed parts of it that didn't go to the heart of the statutory and free speech arguments. But what I thought was really remarkable about it was that the judge so meticulously and methodically goes through, and there are many, many, many different issues, and on every single issue, the judge clearly lays out the arguments on one side and the arguments on the other side, and then explains very clearly why he opts in favor of one. So it's a really excellent exposure to open-minded analysis. And to underscore that, the judge candidly says, I believe near the end of the opinion, I approached this case assuming that the law was appropriate, consistent with the statute and consistent with the charter. I was inclined to rule in favor of the government. And then very diplomatically, he says, and that was reinforced by the excellent arguments that were made by the Attorney General. And then he said, but, on reading the arguments that were made on the other side and really reflecting and thinking hard, I changed my mind. And I thought, that is so extraordinary. Again, such a wonderful role model that we should all follow about being open-minded and being willing to not only, that you shouldn't be embarrassed about it. I think you should be embarrassed if you don't change your mind, right? If you're not open-minded enough to do that. In fact, one of my friends who's a political philosopher is writing a book whose title is, "What Would It Take for Me to Change My Mind?" And I thought, what a great title. Because it's not if, it's what. For all of us, if we're truly open-minded, there has to be some answer to that question. But on the merits, I thought I was quite persuaded that the standard for an emergency had not been satisfied, and also that there were violations of freedom of speech rights, especially for those who were not engaged in any kind of disruption or obstruction or violence, but were simply acting consistent with their freedom of expression, and yet were swept up in this suppressive order.
Well, that's fantastic. I'm so impressed you've already read the decision that me, a charter scholar, have not read yet properly. So thank you so much for coming here. Will you join me in giving her a round of hand?
Thank you. Great question.